take a break, you can come and get your reflection paper, grading rubric things. So I'll do that then. What I'm going to do is make it all the way through the Takings 2 PowerPoint, because we actually covered most of it. And so there's a handful of important cases, important concepts still to cover. So I'm going to do that. I'm actually going to record it. Joe Rupp's grandmother passed away, so this will be a way that he can kind of plug in. So like I mentioned, if you are going to have to be absent or whatever, contact me and see if there's not a way that you can be present. In other words, to avoid being absent. I can't just give you some additional work to do outside of. I mean, that doesn't really count as being present. But so anyway, so that's so I'm going to record this. So every all your commentary will be recorded. Just be aware. Anyway. I am doing a charitable fundraiser contest that I'm going to do on Facebook. So is anybody in here leader of the Student Bar Foundation? Yes, no, nobody? All right, so I don't want to create controversy or conflict, but over the years, what I've discovered is the things that I offer as sort of in-kind items to bid on end up is students who don't have any money who are bidding on them, which is sort of, I think, kind of not the point, right? I mean, that you all are funding each other's public interest work seems kind of not what the goal is like to get lawyers who make lots of money, who are like downtown, who come, or wherever they are. I mean, wherever in town they are, but where they come and bid and so forth. And instead, if it's mostly students and professors, that doesn't seem it. So this year. I'm taking I will take 10 people to the Kentucky Reggae Festival, which Connor won last year at the Student Bar Foundation. And instead, and actually his picture appears here. But instead of doing it as a Student Bar Foundation thing, I am doing this on Facebook to raise money for the Louisville Olmsted Parks Conservancy, New Roots, the West Jefferson County Community Task Force, and the Kentucky Waterways Alliance. And so so whichever fundraiser raises the most money, that team of 10 students is the group that gets to go to the Reggae Festival. So that's the idea. So I currently have, so I started with the first years. And so they have teams signed up for the Louisville Olmsted Parks Conservancy and New Roots. So I brought this today to y'all in case you want to put teams of 10 of you together. If 10 of you like each other enough to go to a reggae festival together with me, and you like me well enough to put up with me for the reggae festival, there's still the West Jefferson County Community Task Force and the Kentucky Waterways Alliance that are looking for teams to, and you don't have to do anything. You don't have to contribute money. Of course, the more that you direct your friends, family, random strangers who have money to give on Facebook to these, the more likely it is that your team is going to be the one that wins. So anyway, just a little competition to try to make our community better by supporting the good work that's done out there. So questions about any of that? All right. The other thing is for next week, we are going to have a class session that's sort of special topics or advanced topics. So if there is something that you want to see addressed next week, email me now, this evening, or tomorrow. Okay, so I got to have enough time to plan ahead, and I have some ideas in mind. But if there's something in particular that, and when we're talking about is something that's kind of broad interest. So like gentrification or green gentrification, that's sort of a cutting edge advanced topic that we can talk about. Sort of what should happen at the corner of 4th and Oak, that's probably a little narrow, right? I mean, so something that we can kind of tackle the interrelationship of legal and planning issues. And I will pick 2 or 3 of the requests I get and work them into a class session for next week. Okay, but a fair amount of the time next week will be spent meeting in your teams for the hearing. So, questions? No. All right. So let me start the recording. All right. So session being recorded. Good. All right. So takings. This is the second part of takings, and as we covered last week, the basic concept is the U.S. Constitution protects private property rights from certain exercises of government authority. The Due Process Clause, which has both substantive due process concepts and procedural due process concepts, is one such protection. And of course, we saw the U.S. Supreme Court engage in due process analysis in the Euclid case, assessing the constitutionality of zoning. And then also, by the way, in the Nectow case, looking at the application of the rational basis test with a fairly debatable standard as applied to a particular parcel, particular zoning, and so forth. And we've seen also some of the procedural due process issues. But what we're focused on now is the Takings Clause in the Fifth Amendment to the U.S. Constitution, made applicable to state and local governments through the 14th Amendment Selective Incorporation Doctrine. Just a reminder, the Takings Clause says, nor shall private property be taken for public use without just compensation, and so the issues are private property, taking, public use, and just compensation. And the types of takings, we talked about, well, of course, sometimes the government doesn't take property, but it acquires property voluntarily through a voluntary sale from the landowner to the government. The government also can take property by just affirmatively exercising eminent domain, choosing to take the property that the landowner does not voluntarily want to sell. And I just want to be clear that in Kentucky and most states, in fact, actually, I don't know of any state that's not like this, the government has to first try to engage, to reach some sort of voluntary arrangement to acquire the property before they start exercising eminent domain power. Okay, so, and of course that makes sense, right? That makes sense that would be the case. The 3 big types of takings where the government acts in such a way that it can be considered a taking, but the government doesn't admit that it's actually taking property. One is physical or possessory taking. We covered that last week. Regulatory taking, we covered that last week, and that's actually where quite a bit of zoning and land use regulation, those issues appear. This week we're going to cover exaction takings, where the government demands that the landowner give the government or the public a property interest or money in exchange for a permit to use the land. So as part of a land use regulation, the landowner has to get a permit, and one of the conditions is that the landowner provide a property interest or some sort of money in exchange for the permit. And then the last thing is we're going to talk about judicial takings, whether this actually is even a category or not is a little unclear. And then we're also going to talk about temporary takings and ripeness. Temporary takings aren't a different type of taking. They're actually about how, usually they're regulatory takings, but they can be other kinds. They can be physical or possessory or exactions. but they're takings that do not last indefinitely, but instead only are for a limited period of time. And then ripeness is an issue about when can the landowner bring a claim against the government. All right, so exactions. Our first test involving exactions is the Nolan Essential Nexus Test, and that's N-O-L-L-A-N, okay, N-O-L-L-A-N, and that's going to be important because the second type of exaction test is Dolan. So, you know, I have no idea if the Supreme Court was doing this on purpose, right? And, you know, they'll, have Smolin and Roland and so on and so forth. I don't know. Anyway, so Nolan, the test is that the exaction must bear an essential nexus to the legitimate government purpose for which the exaction is demanded. Okay, so the exaction must bear an essential nexus to the legitimate government purpose for which the exaction is demanded. So once again, when we talk about exaction, what we're saying is that a permit, a land use permit or environmental permit, is conditioned on the landowner providing either a property interest to the government or public, or money to the government or public. And by the way, we'll talk about the money in just a bit, but that's sort of the idea. The case, Nolan versus California Coastal Commission, arises out in Ventura County, California, which is the county north of Los Angeles. And this is the house that existed prior to the Nolans seeking to tear it down and replace it with a larger house. So this is what the court refers to as a beach bungalow. Okay, so it's a small beach bungalow. And the, actually let me turn some lights down here, but not too much because I'm also going to have to draw some things on the board for you. So the idea here with this is that in California, the voters in the 1970s passed a referendum, a voter initiative, actually, I apologize, voter initiative. So voter initiated legislation to establish the California Coastal Act and the California Coastal Commission to regulate land use within the coastal zone. So the coastal zone is the area right along the coast. And the idea here is that in California, the coast is subject to public rights and the public trust. What was a concern is that there was a lot of private land development that was blocking public access, that was causing environmental harm to the coast and causing harm to the public's rights and interest in the coast, so the ocean and the beach and the coastal area. And so the land use regulations in the coastal zone are what we call a regulatory overlay. So we talked a little bit about that the very first class period, but we talked about how state and federal regulations can be overlaid on top of local regulations. So they don't displace the local regulations, but the idea is if you need, if say for example you're the Nolans and you want to replace a little beach bungalow with a big beach home, right? Then you are probably you're going to have to go to the local government, Ventura County or Oxnard or wherever this happens to be, whichever jurisdiction this happens to be in, and you have to get the local approvals, but you're also going to have to go to the California Coastal Commission and get a permit from them. The California Coastal Commission has taken its mission very seriously and is a very strong land use regulatory agency in California. And they make lots and lots of decisions about permits, and they're fairly aggressive about protecting the public's interest in the coastal area. And so one of the things that the California Coastal Commission said is that when these kind of beach bungalows are replaced by these kind of large homes, okay, because this is actually the actual house that the Nolans built that replaced that, right? So the top is what the old, the bottom is the new. What they said is that these big, massive homes on the coast were blocking the public's visual access to the beach, okay? The public's visual access to the beach. So what do we mean by that? Well, here is Pacific Coast Highway, which is also known as PCH. Has anybody ever driven up and down PCH? Okay, a couple of you. Okay, again, I'm going to say once again, you guys need to get out. Okay, so, all right. So, and the thing is, so here's a little, oops, it's not going to work. Here's a little beach bungalow here. And here, let's assume, is a massive house. And out here is the Pacific Ocean, right? I will spare you my artwork of drawing Professor Arnold out there surfing, okay? So, but nonetheless, because it would be a stick figure, right? But anyway, so, you know, and here's beaches out here and so forth. And so the idea is that as the public is driving along Pacific Coast Highway, when all these little beach bungalows where you can see past them, you can see the ocean, when they're replaced by these massive homes, the public loses sight of the ocean and therefore suddenly becomes unaware that there is an ocean out there. Okay? And it is Pacific Coast Highway, so you would hope that people living in California would be like vaguely aware there's an ocean over there. But nonetheless, okay, the Supreme Court takes this on its face value, that's indeed what they're saying that they aim to do, that the California Coastal Commission has a legitimate interest in addressing the loss of the public's visual access to the ocean by a lot of development that blocks the view from the public road, from the Pacific Coast Highway. Okay? So fair enough. What went on, though, in the case, though, was that there was a beach here and a beach here, and this is the Nolan's house, and it's sort of rocky cliffy there. Right? So rocky cliffy being a very technical, precise legal term. Okay? And so what the California Coastal Commission said is, we will grant you a permit to replace this with this, right? If you grant to the public an easement that allows them to cross from this beach up onto your property and back down to the other beach, what we call a lateral easement. Okay, lateral meaning that it lies across the ocean front, right? But on the Nolan's property. Okay? Now the question is, how does the lateral easement serve to address the public's lack of visual access from Pacific Coast Highway? Right? That's the point, right? That's the problem that the Supreme Court has with it. I mean, actually, they're totally fine that there might be a legitimate interest for asking for the lateral easement. They're totally fine with the idea that the Coastal Commission can address the public's lack of visual access, but the visual access was the justification offered by the California Coastal Commission for the lateral easement, and there's no connection between the two. One does not serve the other. One's not a solution to the other, right? And so the court says there's no essential nexus. There's no essential relationship between the two. And so therefore, this demand for an easement is a taking. So let me show you the picture. So this is where they're gonna go up the steps. And you see it's rocky, and there's like a seawall sort of thing there, and so forth. So here's the beach. They're gonna go up the steps and across the Nolan's property and down the steps on the other side. That's sort of the idea. So the court says there has to be an essential nexus. This test is incredibly easy to meet. And I do not mean to be flippant, but I do mean to get your attention and get you to think about this, because I call this the how stupid is your government lawyer test, okay? And I was a government lawyer. I mean, and then eventually I was a planning commissioner, right? Okay, so I am not at all suggesting that they are stupid. What I'm saying is that they're not stupid, and any government lawyer worth whatever they're getting paid can come up with a legitimate government purpose for whatever the regulators want, right? Does everybody see that, right? So if the regulators want X, then the government lawyer can then articulate for them what the legitimate government purpose in asking for X is, right? It is not hard to establish the essential nexus, okay? So this is a really low bar. Okay, and part of what was happening here is that the California Coastal Commission, at the time, I went to a land use conference. It was a UCLA land use conference, and their executive director, they were doing very important environmental land use work, but their executive director really kind of didn't have much use for the takings clause in private property rights. And so he sort of said that at the conference, and basically said, well, we don't care that the Supreme Court is holding that some of our regulations are takings, because the Supreme Court can only take so many cases that involve the California Coastal Commission, so we're just gonna keep doing it. And let them take as many as they can, but we're just gonna keep going on. Okay, that actually didn't go over very well, because what is that? Well, I mean, that's sort of a disregard or disrespect for the rule of law, and there were of course a lot of people who were very keen on what the California Coastal Commission was doing, but they didn't like that attitude. I think the other thing is, by that point, the executive director was a little bit older and grumpy and sort of outspoken, and so he was encouraged to retire. But the Coastal Commission continues to regulate, to protect the coast in California. But nonetheless, the essential nexus is there, and it's there in part because the Coastal Commission was sort of cavalier about the relationship between the exaction that they were seeking and the legitimate government purpose. But as one could just inevitably predict, the action didn't stop there. So then along comes the Supreme Court about 7 years later in the case of Dolan versus the City of Tigard, and came up with a second test. Okay? And these are not alternative tests. Okay? So Lucas is a test, and then Penn Central is an alternative way of evaluating whether there's a taking. Loretto is one test, Kaiser-Etten is a different test. In contrast, in the exactions, essential nexus and rough proportionality are both, right? Every exaction has to meet both. So every exaction has to have an essential nexus to a legitimate government interest, and the type or nature and the extent or scope of the exaction must be roughly proportional to the impact of the proposed land use which the exaction is meant to address. Roughly proportional. So you've got the exaction, you've got the impact of the proposed land use, and there has to be a roughly proportional relationship between the two. Roughly proportional in terms of the type of exaction that's being asked for, and the amount, the scope, the extent of the exaction. Okay? So type or nature of it and the amount, the extent, the scope. The court does make a point, though, that no mathematical exactitude is required. So those of you who love to look at impacts of land use using quantitative data and doing sort of data analysis and so forth, that's awesome, but it's not required. It's not required. So in other words, kind of rough estimates are okay because it is indeed roughly proportional, not exactly proportional. So, but the thing is, what the Supreme Court says is that the local government has to make some effort to try to assess what's the impact of the proposed land use and how much exaction and what kind of exaction is going to be needed to address that or mitigate that impact. So let's look at the problem, the issue in the case. So this particular case, Dolan versus the City of Tigard is actually one of our takings widow cases. So and I bring this up because I actually think the Supreme Court justices who are choosing to take these cases are doing something very in particular. They are of all the takings cases that they could accept in a given term, and then next term and the following term, so forth. They are looking for property owners who do not meet the standard image of the big, rich, greedy developer, right? So, and we're going to talk about another takings widow case where the property owner is literally wheeled into the Supreme Court chambers in her wheelchair. Okay, actually I'll tell you the whole story of that oral argument. It's interesting. But what's happening is the justices, I think, are trying to make a point that property owners and developers and land, people who are seeking land use permits involve, everyday widows out there. So it started out where the Dolans, a couple, own this hardware and plumbing supply store in Tigard, Oregon, and what happened is, of course, over time, Mr. Dolan passed away, and so then Mrs. Dolan, as the sole property owner, ended up being the sort of the surviving plaintiff in the case. What happened is they wanted to expand their store. So this is the store up there. And what they wanted to do was to expand the size of the store and the size of the parking lot. Okay, so when that happens, there are going to be two big effects, right? One is, hopefully, to the Dolans, what they're aiming to do is to increase the number of customers, right? Right, everybody? Right? They want a bigger parking lot, bigger store, more merchandise. They're looking for more customers, right? Okay, so more visitors to their site. The other thing is, okay, they are expanding the footprint of the building and the amount of the parking lot. What's that going to produce more of?
Runoff.
Runoff, stormwater runoff, right? It's more impervious surface, so it's going to produce more stormwater runoff. So what happens is that the City of Tigard says, first of all these new customers coming down to this expanded store are going to create increased traffic congestion in bustling downtown Tigard, right? And so they say one way to deal with that is to create a bike path so that people, when they are going down to pick up their plumbing supplies, can ride their bicycle down and put the plumbing supplies in their basket and ride home, right? Okay, I'm being a little facetious here. But again, okay, so partly I got your attention, but the Supreme Court has no quarrel with that whatsoever. They say, okay, there's an essential nexus between mitigating the impact of more traffic and asking for a bike path. Right? So they're not questioning whether people go, because people might go pick up nails or something small, right? I mean, so it's fine, right? So they're not questioning whether that there's an essential nexus. The thing is that they say there has been no analysis by the city as to how much traffic, new traffic, additional traffic, the store expansion is going to generate, and how much bike path is then attributable to the Dolan's project. Okay, so I mean, their concern is, the Dolan's may, have 3 or 4 more car trips per day, and instead are being asked to build, a 20-mile bike path looping through the city of Tiger, right? So that's the concern. It's the amount. Okay, there's no quantity of bike path versus quantity of car trip comparison. Okay? So that's one thing. The second thing is that city conditioned the approval on the setting aside of a riparian buffer zone on the Dolan's property where it borders Fano Creek. So this is Fano Creek here. It's a little creek that runs through. You see pretty trees growing all up against it and so forth. And they say that this sort of riparian zone is meant to be a no development area. So no further expansion, no development. The Dolans are to grant an easement to the city that prohibits any development. So in essence, a conservation easement of sorts, right? To the city that prevents development. But it also included that they would be required to allow the public to come and picnic on the banks of Fano Creek on their property. Okay, so this is where the court says the type or nature of the exaction is not necessarily roughly proportional to the impact of the project, because the impact of the project is stormwater runoff. Why does the public need to come and picnic on the land, right? So again, it's not that the riparian buffer zone doesn't meet an essential nexus test. It does, but it is not roughly proportional to expect the Dolans to allow the public onto their property in the riparian buffer zone. So that's the essence. Now, again, I mentioned this about the Lucas case, but this is again an example of when this came out. There was great weeping and gnashing of teeth. There was a lot of concern that Nolan and Dolan were going to create a severe barrier to local governments and state and federal governments, for that matter, imposing exactions on landowners and developers as part of the permitting process. And again, when this came out, I thought, well, these are not hard to meet, and actually best practices were already to try to somehow match the type and extent of the exaction to the actual impact of the project. Because one of the things you want to do, as you know from your own work with the West End Walmart, is to think about exactly what is the impact of the project, right? And try to assess that. So there was a lot of concern. And I think, to be honest, to be fair to the critics, I think the concern was the Supreme Court just making up these rules out of thin air? But nonetheless, one of my good friends, who is an ardent environmentalist and environmental law professor at UCLA named Ann Carlson, got together with a social scientist to assess what actually happened to exactions after Nolan and Dolan. In other words, let's look at the actual impact of the Supreme Court decision. And what they discovered, okay, so by the way, Anne is going to be somebody who's more likely to be critical of these kinds of cases, right? So you know, her predisposition would be maybe to think that this is going to be not good for exactions, okay? So, but what they found was that prior to Nolan and Dolan, because the law was uncertain, local governments were actually under-exacting, asking for too few exactions. Once local governments, especially after Dolan, started having to assess the impacts of proposed land uses and what kinds of exactions and how much were needed to mitigate those impacts, they started developing a whole set of assessment tools, a whole toolbox of exactions, of different kinds of exactions that could be imposed. And what they found was that they had been under-exacting. And so actually the amount of exactions increased after Dolan, which is interesting, and again, sort of counter to what people predicted. And it makes sense, and right in retrospect, you know, it's one of those brilliant articles. It was like afterwards, you're like, of course, that makes total sense. But at the time, you know, the common wisdom was that local governments, you know, would be squelched by these cases. So, in my view, part of one of the outcomes of all this is it's actually improved the quality of demanding exactions from landowners. One of the big issues for a long time, though, was did Nolan and Dolan only apply when the exaction was a property interest? And the exaction was a property interest, because the whole idea is, you know, land use, or these takings is about the taking of land, right? I mean, so taking real property, and so, you know, it does only apply when it's an easement or you know, a buffer zone or a bike path or that kind of thing. What would happen if, as many local governments started doing, they were to instead demand that the developer or the landowner pay money into some sort of mitigation fund or impact fund or something? So schools, right? So instead of requiring every developer of every subdivision to build a little tiny school just for that subdivision, instead what happens is local governments demand that they contribute to a school construction fund, right? Or roads, right? Sometimes, you know, developers build roads in the subdivision, but what about, you know, improvements in the major arterial highways that connect to that subdivision? Well, we're probably not going to have the developer go out and do it themselves. Instead, what we're going to have is have them contribute to a public fund that is designed for that. And we talked a little bit about that previously when we talked about growth control. Well, the question is, did this apply to monetary exactions? So Nolan and Dolan apply to monetary exactions. And some courts said no, some courts said yes, some courts said only if the amount is negotiated on a you know, permit by permit basis, as opposed to being a standard fee that's just imposed, you know, that's developed by regulation or ordinance and just imposed across the board. So, of course, the U.S. Supreme Court takes this up in 2013 in Koontz versus St. Johns River Water Management District. And as you might expect, the Supreme Court, especially the current Supreme Court, or the not that long ago Supreme Court, says, oh, yes, government regulatory entities imposing monetary exactions as conditions of land development or land use permits must meet the Nolan Essential Nexus test and the Dolan Rough Proportionality test, even though it's money rather than land or real property that's being exacted. And that is also true even if the permit is denied for failure to agree to the exaction, to the condition that imposes the exaction. Okay, so bottom line, Nolan and Dolan apply to monetary exactions. Why? one of the things that the Supreme Court said in the Dolan case is the basis for the whole exactions takings area is the potential, the risk that the government can extort more than the landowner would reasonably be expected to provide simply because the landowner is desperate for the permit. Okay, so the landowner is desperate for the permit, they can't build, they can't develop without it, and so the potential for the local government to use the permitting process to get, basically public benefits out of the landowner. So that's supposedly the theory. And so what they say in Kuntz is that same potential to extort too much exists with monetary exactions as well as with land or real property exactions. Okay? And so that's the gist. And I don't have an interesting backstory here. This has to do with water management and flooding. By the way, though, I will mention that because some of the students who actually maybe none of you do know this. It's my current first years that know this. Okay, so Florida, you might not know, but Florida has 5 regional water management districts that are organized around basins. And they were a state that took the leadership among eastern states in the 1970s by shifting from traditional common law riparian doctrines for water rights to creating what we call regulated riparianism, where all water permits, the permits to use water, permits to pollute or affect water quality, all kinds, anything with respect to water, you have to go to the regional water management district. And like I said, there are 5 of them, and get approval. And they have these standards, these statutory standards, including, among other things, impact on the public interest. Impact on the public interest is one of the standards. So it's a very interesting system, and so you get these sort of region-wide, basin-wide management of water. But among other things, what they did was require a developer to pay fees, and the developer said no, and so they denied the permit, and so then the developer says the fees violate the Nolan and Dolan test, and the Supreme Court says Nolan and Dolan apply. Okay, so actually they send it back to the lower courts to determine whether the fees met the Nolan or Dolan test, but the basic gist of what the Supreme Court says is, well, Nolan and Dolan apply. Couple of things. Don't get carried away. Fees that are user fees. Okay, so for example, the local government requires you to pay a fee when you apply for a permit that's a processing fee that's basically designed to cover the government's cost of having to staff the zoning office and process your permit. Okay, that is not an exaction. Okay, that's a user fee. Okay, when you cross the Ohio River bridges, right? Okay, so you might end up joining this class action suit, right? Anybody see the class action suit against the? No, nobody see it. Yeah. So there's this class action suit saying that they're overcharging. Okay, so maybe they are, but nonetheless, you drive across the Ohio River bridges and you get charged a fee. Okay, that's a user fee. That is not an exaction. So sorry, there's no Nolan and Dolan or something in there. Okay. The other thing to be aware of is conditions regarding how you use your property are not exactions. Okay, so some of the things that we talked about with the Weston Walmart, the binding elements, okay, not necessarily exactions. Okay, so for example, if you for example, you can only have you have to have a certain amount of windows in the property, right? Or you have to have 2 entrances. Okay, those are not exactions. Now, what gets a little tricky is what happens if you're required to plant trees on your property. Okay? Ooh, now that's a little different, right? Because, on one hand, that's sort of a condition about how you use your property. You're supposed to landscape it, right? Okay, that serves all sorts of purposes. On the other hand, that starts getting more into, you're having to provide something to the public, right? So I don't know about the trees in the long run, where we'll go with that, or if the Supreme Court will actually ever get that interested in it. Nonetheless, best practices, right? If you're really serious about asking landowners to plant trees on their property, my view is you should be. I mean, my view is that we need them, but you should be asking for the number and type of trees that offset the adverse impacts of the project. In other words, go ahead and meet Nolan and Dolan. It's a good rule of thumb, generally, to guide good decision making. Right? All right. Judicial takings. So we do not know if this is a type of taking or not. This theory has been out there for a while. One of my professors at Stanford wrote about this a long time ago, about whether this is actually a type of taking or not, and so we don't know. But the idea is when the government, when a judicial decision eliminates a property owner's property right. So, say for example, when a state court changes property law, and they can do that, right? Happens all the time, where we have some ancient doctrine out there. Talked about Indiana has the common enemy doctrine with respect to floodwaters, that basically you are authorized in Indiana to throw the floodwaters onto your neighbor. Okay? Well, not literally onto the neighbor, but onto the neighboring property, right? Okay? Because the idea is it's a common enemy. This is a very old doctrine that comes to us from England, and it is outdated, it's stupid, and nobody likes it. But nonetheless, the Indiana Supreme Court keeps sticking with it because it is precedent, because it is the law. So what would happen if the Indiana Supreme Court got with the program and overruled that doctrine, basically replaced that doctrine with the more modern doctrine, which is that a property owner does not have the right to flood their neighbor's property. Well, a landowner who has been flooding their neighbor's property might bring a takings claim saying the Indiana Supreme Court has judicially taken their property, right? Their property right, maybe not their entire property, but certainly that right to push the floodwaters onto their neighbor. Okay, and the question is that a taking or not? Well, in the Stop the Beach Renourishment case, the U.S. Supreme Court took this case on, and lo and behold, one of the things that they sorry, this seems to have frozen up here. What's going on? So anyway, so what they did in this particular case is Justice Stevens owned beachfront property in Florida, so he recused himself. And so what we were left with, and by the way, this is 2010, so it's 10 years ago. And so what we were left with were 4 justices who voted to determine that there is such a thing as judicial taking, and that if the court does that, the federal courts need to invalidate, to strike down what the state court did, which is crazy, I think, because state courts are entitled to change state property law. That's always been the case. So that seems weird to me, but that's just, okay, I'm obviously offering an opinion on that. Secondly, two of the justices said there is no such thing as judicial takings, but they would have the federal courts review a state court's change in state property law and determine that the state court had violated substantive due process if it was an unreasonable, arbitrary and capricious, sudden, radical change. And then two of the justices said, no, we should not recognize judicial taking. However, part of what went on in the case is none of this actually was necessary to the case, to resolution of the case itself, because what they said is that the Florida had not changed, the Florida Supreme Court had not changed the Florida property law, and that there were no pre-existing property rights. So this case involved this process of renourishing beaches, which is where the federal government and the local government work together to add sand back to beaches that have eroded. Okay? And one of the things that this case points out is that there is this erosion happening in Florida, and when at one time there were beaches that needed to have sand re-added to them every 7, 8, 10 years. Then it was every 5 years. We are now down to, in many of these beaches, every 2.5 years. The entire beach has eroded away, and sand has to be added to it. Why? What's going on? Well, some of this has to do with environmental changes, sea level rise, the intensity of hurricanes and storms and storm surge and some of that kind of stuff, things that are associated with climate change. And some of it has to do with land development practices. We have developed those coastal areas so much, and not just in Florida, but all over everywhere, that the natural processes that allow the beach to adapt no longer work. And so we have mass erosion happening. Anyway, but the issue had to do with, really, it had to do with when the coastline changes, where does the property line go? And what was happening is that the local government and the federal government were bringing the sand in, renourishing the beaches, but then what that did is it put a whole bunch of beachgoers right at the beachfront property of people who lived on the beach, and they didn't like it. And in some fairness, there were some news stories that reported things like people would find members of the public in their hot tub, conducting a wedding under the arch to their house, at the entrance to their house, picnicking on their porch, that kind of stuff. And so there was, and basically the bottom line is, you get a little bit of a tension there between the public use of the beach and the private property rights. All right, I am going to have to do something here because this apparently has frozen up. So let me see if I can get this. There we go. Okay. No. Control-Alt doesn't work. Anybody have any thoughts?
You tried turning it off and back on again?
Yes.
Hit it a couple times on the side.
Like that?
Just the rabbit ears.
What's going on here?
Yeah, force quit.
All right, so I'm gonna have to. All right. Let's take a 5-minute break. We'll come back. We're almost done, but we got a little bit. This slide is just a picture of some of the land development along the panhandle of Florida, and the beach has been added, and it's to the ocean and so forth. You get some of that. All right. Last topic, temporary. Actually, I apologize. Second to the last topic. Very last topic. Temporary takings. All right. So, in 1987, the U.S. Supreme Court took on a case called First English Evangelical Lutheran Church versus the County of Los Angeles. This case involved the Luther Glen campground, a campground for kids in the Angeles National Forest in Los Angeles County, and the campground had been totally flooded. And because it, and basically, as you might imagine, we have over time expanding floodplains. Partly because of development, partly because of climate change, partly because of changing patterns of flooding and so forth. And so the County of Los Angeles refused to allow the Lutherans to rebuild or occupy their campground, because they said, you know, we have a public interest in not having little kids at the campground die from flooding, right? So that was basically the bottom line there. And so they were sued, basically the church says, hey, you are taking our private property because we can make no use of it, no economically viable use of this property because we can't do anything there. And so what happens is the county says, oh goodness, we don't want to do that. We don't want to have to pay the Lutherans for this property, so we will lift the regulation and allow the kiddos to get flooded and drown and push away, right? Okay. So anyway, but there had been large amounts of time, years and years, in which the Lutherans were unable to use the campground. And so this gets to the Supreme Court, and the Supreme Court says that when the government has taken a landowner's property, it owes compensation for that time period in which the property has been taken, even if the government later lifts the regulation and allows the owner to use the property. So this is what's called a temporary taking. So the government's duty to deny, or duty to compensate a landowner for denial of all economically viable use of the property for a time is not eliminated just because the government repeals the regulation or allows the landowner to bring a takings claim. Okay? So, and of course, as you might imagine, in my property rights field research class that I taught in California, we went to the Luther Glen campground, which is pictured there. There was no flooding happening at the time. I'm happy to report. I did not put any law students' lives in danger.
Or little kids.
What's that?
No little kids either.
No little kids either. Right? So yeah. Next, though, is what effect does that have on moratoria? Right. So we talked about development moratoria earlier, and the concern here is, well, if any taking for any amount of time triggers the requirement for just compensation, is the government having to compensate all landowners who are subject to a developed moratorium for the time frame of a temporary moratorium. And the U.S. Supreme Court in 2002 in the Tahoe Sierra Preservation Council versus Tahoe Regional Planning Agency says no, that a temporary development moratorium adopted in order to study conditions and develop reasonable tailored land use regulations is not a per se taking. So it's not a temporary taking. But the court says there are two considerations here. How long is the moratorium for? And they said, after about 18 to 24 months, it's going to start becoming a taking. The other thing is, what's the purpose? So if the whole point of the moratorium is to put a pause on development while you develop reasonable, more carefully tailored land use regulations, you study the issue and move forward with something, that's fine. That's good, actually. But if you keep extending the moratorium, or the whole point of the moratorium is some sort of pretext to basically force proposed development to just go away, right? To give up on pursuing the development, then that is not a legitimate purpose of a moratorium, and it will be a taking. Okay? So, and we talked about this before about Tahoe, Lake Tahoe being an especially clear lake, and the whole idea was that there were a lot of development around the lake was causing the clarity to decrease, and so that's what the moratorium was. Now, as a practical matter, one of the problems here was that the moratorium in reality lasted 8, 9, 10 years. Okay, so it was it. But what happened is the landowners' lawyers brought the claim really fast because they thought, I'm looking at First English, any moratorium for any amount of time was going to result in a taking, and therefore their clients would be compensated. And so the trial, the record before the trial record before the U.S. Supreme Court was it was about 18 months was what the moratorium had been at that point. So that's all the Supreme Court considered. Now the final issue, ripeness. At what point may a landowner bring a takings claim in court? So back in 1985, down here in the Nashville area, there's a case that came forward to the U.S. Supreme Court, Williamson County Regional Planning Commission versus Hamilton Bank. And in this particular case, actually the facts are totally irrelevant. We're not going to talk really about them, but what the Supreme Court did was come up with two rules. And one is that what's called the final decision rule. And they said that a takings claim is not ripe for adjudication for decision by the court unless the plaintiff has sought all available permits and exhausted all available appeals. Such as, say, for example, if the Planning Commission denies the permit, you appeal it to the City Council. Okay? So that's the idea. And the point here is the court says they need to be sure what it is that the local government will allow and not allow. So if you say, oh, gee, I'm required to get a conditional use permit, I don't like that, so I'm just going to sue the government for a taking. The court's not impressed because they're like, you could apply for the conditional use permit. If you got the conditional use permit, there'd be no taking, right? So they want you to apply for the permits. Like I said, if the Board of Zoning, let's say it's the Board of Zoning Adjustment, denies your permit, and the local land development code allows you to appeal that to the City Council, okay? There are lots and lots of circumstances in which a City Council will overturn its Board of Zoning adjustment and grant the permit. That might happen, right? So you need to at least do that before you go to court. Now, if you appeal to the city council and they deny it, now it's time to go to court. So that's the final decision rule. The other is the state compensation rule, and that basically says that you have to use the state court system for seeking compensation because the remedy for a taking is just compensation. And so if it's a local government or a state government entity that has regulated your property or taken your property, you need to go to state court and seek state compensation from the state court. This, by the way, was overruled, so we'll just go 2 slides later. You'll see just last year the U.S. Supreme Court overruled the state compensation rule. Okay, now what you're going to see out there is Williamson County has been overruled. Okay? The final decision rule was not at issue in the case, in the 2019 case. So I'm not sure that I would not assume that the final decision rule has been overruled. And in fact, over the years, the Supreme Court has continued to stick with that. What has been overruled is the requirement to go to state court first. Why? Well, what had been happening is landowners were getting stuck because let's assume for a moment that the government, local government is regulating their property in a variety of ways. And the lawyer for the landowner, or the developer, or whatever, wants to bring a takings claim, but also wants to bring a substantive due process claim, a procedural due process claim, and equal protection claim, and a First Amendment claim. Okay? Right? So, right, you can imagine scenarios where that's the case. Denial of denial of use of property for religious land uses, right? So that could involve free exercise, it could involve equal protection, it could involve substantive due process, and if it's just, maybe they didn't hear the evidence, so denial of procedural due process. The thing is that all of those other claims can be brought in federal court under a statute called 42 U.S.C. Section 1983, okay? USC is the U.S. Code, that's where all the federal statutes are. Section 1983 is a section of Chapter 42 of the U.S. Code that was adopted in the post-Civil War era to allow people who were trying to assert their constitutional rights to sue the government, including the state and local government, for damages for violation of their constitutional rights. Okay, so that's what that. So it's a statute that allows lawsuits in federal court, to basically assert your constitutional rights and say you've been harmed, you've been damaged in some way. So you get prisoners who sue for violation of their constitutional rights under 42 U.S.C. Section 1983. People who've been investigated or charged with crimes. People who say that I wasn't allowed to have my protest or my march or whatever, and so on and so forth. Okay, so. The problem is if you tried to bring your takings claim with all your other claims in federal court, your takings claim was going to get thrown out under Williamson County, and so by the time it got thrown out, the statute of limitations on bringing your takings claim in state court had already passed, and so you basically lost out on bringing your takings claim. If, on the other hand, you brought your takings claim in state court, you often then had 2 lawsuits going on over the same thing. You had the state one and you had the federal one. And there might be various issues there where, hey, we shouldn't have 2 different courts hearing claims about the same problem, the same basic underlying facts. So it became, so that's sort of where this goes to where the Supreme Court overrules this in 2019. I'll talk a little bit about that in just a second. Actually, let me jump ahead and then I'm going to come back to suit. Okay? So the Supreme Court overrules the state compensation rule of Williamson County in Nick versus the Township of Scott. And here is what they say is a takings claim is right for adjudication in federal court whenever the government takes property without compensation, regardless of whether the plaintiff has sought compensation from the state or locality using the state court process. So in other words, what we go is in order to bring a claim in federal court, you have to have had your property taken and sought compensation to now, as long as they took your property and didn't compensate you, you don't have to seek compensation in state court, you can go straight to federal court. And so they say that the state litigation requirement imposes an unreasonable burden, okay? Now, having said that, so this is a 5-4 decision. The dissent, of course, points out that this is overruling a whole lot of precedent that the Supreme Court has followed for a lot of years. You know, it's you know, what's the justification for that? So that's sort of the concern of the dissent. Oh, by the way, here is, so this is, I think it's Rosemary Nick, I think is her name, Ms. Nick, who is a 70-year-old sole owner, sole occupant. I do not know if she's a widow or not, if she's ever been married. I don't know what the deal is, but she lives alone on her family's 90-acre farm. I think 90 acres is the right amount. I don't know, something like that, bunch, in Pennsylvania. And the farm has has a little cemetery-like thing. It has graves of some of her ancestors who, from a long time ago, right, back when people buried their family members on their farm, right? Okay. The state passed a law requiring people who have cemeteries on their land to make them open to the public from like 9 to 6 or something like that. Or so she was complaining that, hey, well, but the other thing is the officials who were responsible for enforcing that law issued a citation for her because she didn't have her property open to the public. And so then she, of course, sued. Of course, they withdrew the citation, but by that point, you know, the lawsuit was underway and so forth. And anyway, but she, of course, brought this in federal court, and so the question is, you know, did the federal court have jurisdiction to hear it, or should she have brought it in state court to begin with? And of course, the Supreme Court says, yeah, she can bring it in federal court. But anyway, so you get the idea there.
Are any members of the public ever even interested in going on her
I
property?
have no idea. I have no idea. I mean, you know. But of course, now you can imagine that there might be people who are like, oh yeah, I want to go see her cemetery as an excuse to, like, I mean, it looked pretty, right? I mean, I'd go hiking there, right? So as a pretext for being able to wander around her property, right? I mean, even if you're not wandering all around it, you gotta hike in, hike out, right? So, I don't know. But the point is that she wasn't making her property open to the public, and the state didn't like that.
So what are the big implications for that case? Is it that local governments, or since plaintiffs can take it straight to federal courts, that's gonna maybe put more pressure on local governments to consider their actions, or, because it's not really removing a hurdle for the plaintiff, because you could have taken it to state court.
Right. So the thing is that, interestingly enough, state courts end up not being especially sympathetic to property owners on their takings claims. And there's some reasons why that's the case. I mean, I think a lot of times state judges tend to be they tend to be, well, some of them are former prosecutors, right? And so they are people who have stood up every day of their professional career and represented the people of the state of whatever, right? And so they tend to be a little bit deferential to the local government or the state government or whatever on these cases. So, and besides that, they don't hear that many federal constitutional rights claims, right? They're dealing with, you know, various state law, common law issues and state statutory issues and so forth. So, in general, I think there's a perception, whether it's accurate or not, there's a perception by property owners that they will get a more receptive set of judges in federal court. There are a lot of cases out there that suggest that's really probably not true. That a lot of federal judges, including judges appointed by, well, judges who are perceived to be relatively conservative and appointed by conservative Republicans. So a couple that I can mention in the Seventh Circuit, both Posner and Easterbrook, were incredibly hostile to claims brought by property owners that their constitutional rights have been violated. Okay, so I think some of this is a perception that's not necessarily based in reality. But I think what's really going to go on here is it's going to be much easier to package all of these claims. And I do think it makes it more costly for the government to then defend those claims. So if you've got, for example, the Pacific Legal Foundation representing the landowner, and now all of a sudden, you know, the city of LaGrange has to cough up the money to have some high-profile lawyer defend their regulation of somebody's property, I think it does put more pressure on it. If it's a good, go back to your original question, I think that is true. If that makes sense.
Yeah.
Okay, so last case I want to talk about is the Sudum case. Sudum, and this is a Tahoe Regional Planning Agency case as well. This also involved development prohibition in Tahoe, and this is yet another widow takings case. So this is the one where, so the Sudums bought a piece of property overlooking Lake Tahoe, it's in the hills over Lake Tahoe, and it was in the runoff zone in which the Tahoe Regional Planning Agency did not allow any development because development would, you know, damage the lake and the water quality in the lake and the clarity of the lake and so forth. But they provided TDRs, transferable development rights. And so they said to the Sudums, no development at all of your basically retirement home. The Sudums wanted to build their retirement home there. So you cannot do that, but we'll provide you with these TDRs that you can then transfer to some other property or sell to some other landowner as an offset. And so so Mr. Sudum passed away, and Mrs. Sudum, continued with the lawsuit, and they were saying that basically that the court ought to hear their claim for a taking because they had no economically viable use of their land, and all they had were the TDRs. The Tahoe Regional Planning Agency said, well, they haven't tried to exercise their TDRs, so it's not ripe yet. So we get to oral argument, and the attorney for the Tahoe Regional Planning Agency, well, first of all, you get to oral argument, and they wheel Mrs. Sudum in the Supreme Court chambers in her wheelchair. Okay? And it wasn't, I mean, that she really literally was in a wheelchair, right? I mean, so it wasn't a stunt, it was a real thing. And the attorney for the Tahoe Regional Planning Agency, when they get up to make their argument, Justice O'Connor doesn't even let them start. What she says is, counsel, why can't you let Mrs. Sudum here have her day in court? If you're the attorney for the Tahoe Regional Planning Agency, sit down. It's over, right? That is not how you want your oral argument in the Supreme Court to go, right? To start with not even being able to introduce yourself, to immediately have Justice O'Connor say, why can't we let poor Mrs. Sudum here have her day in court? Well, as you might expect, the court says, yes, this is right, because we know for absolute certainty they are not going to allow any economically viable use of this land. TDRs are all about whether she's gotten some compensation or not. You know, it might be relevant, might not be. It does, you know, but the case is ripe. So it might be a form of compensation, but it does not affect ripeness. But it was, of course, you know, got lots of attention. Okay, so that is where we are with takings. Questions? The Supreme Court keeps taking on takings cases, so I think we're going to continue to see things. I think judicial takings is going to come to the Supreme Court again. I think, at some point, who knows when, who knows under what circumstances. I don't know if the Supreme Court's ever going to overrule the final decision rule. Okay? Do you remember back when I talked last week about the Del Monte Dunes versus City of Monterey case, and there had been a series of denials? Well, the Supreme Court dealt with that by saying, okay, the landowner does not have to keep coming back with endless proposals, right? It was pretty clear that the city wasn't going to allow them to develop their property, so their claim was right. So I'm not sure that the final decision rule ends up being anything that people get all that worked up about one way or the other. It sort of makes sense. But I don't know where else we're going to see some of these. I think one of the big areas where there's a lot of tension is not this class. It's actually water and water law and water resources. Under what circumstance has the government taken somebody's water rights? And there's been a lot of cases on that, but the Supreme Court has not really weighed in, and the cases come out in very different ways, but that's not land use. So, any questions? All right. So what we're going to do now, let me turn this off. Stop recording. New session. So sometime this evening, just get that. It was the whole computer that froze up. I mean, I couldn't do anything. So I think I don't know what's going on. All right, so it did one recording already, so that's good. All right, so questions about the Stapleton Ridge problem. Do you have any questions about Stapleton Ridge? So I'm going to come around and meet with each of you all in individual groups. The bottom line, just to kind of reiterate some things from our, some lessons from our first one. So there were a lot of very good work done on the first hearing, so you obviously want to keep doing those. You know, effective communications, effective advocacy, organization of the hearing, and use of facts, etc., use of PowerPoints. Obviously, one thing that everybody should be reminded of, but I said it several times, is if you do a PowerPoint, or whatever you submit, right? I need a copy of it. I can't give you credit if I don't have it, right? So just provide me with everything, whether it's a report, petitions, drawings, PowerPoints, whatever. Another thing to sort of think about is don't forget that you need to not only consider each request, right? So, and that was done correctly in the last one, where each waiver was considered one by one, right? Okay, and the findings that are needed for each one, with what are the findings, some deliberation behind that, and so forth. But also, don't forget to expressly address whether or not, what exactly are the conditions and/or binding elements associated with that, right? If they're in the staff report, sometimes as a practical matter, if they aren't expressly addressed in the hearing, then they just throw in the minutes that included the ones in the staff report, but that's a little sloppy, right? The decision makers, and you don't need each and every decision maker to say it, just somebody needs to say it. Or the planning case manager or the attorney needs, for the Louisville Metro, needs to say, does that vote include the staff's proposed conditions or binding elements and so forth, right? But think about how you can use those conditions or binding elements as means to modify the project, to come up with some solutions to some of the adverse impacts of a project, right? I mean, you don't have to take the staff. The staff proposals aren't just a accept or reject, right? They can be added to, modified, taken away from, right? Does everybody see the thing there? So you want to sort of think about that. Framing, the best presentations are ones where the framing is clear up front. So again, I want to reiterate that and think about that. Keep working along on the teamwork. This one's a little different. We're in the suburban area, and one of the things I want to call your attention to is there are actually now several different types of ways that this property is regulated. Right? There's several different kinds of environmental impacts, right? Is everybody following me? Yes? Does that seem to resonate with what you're finding? Right? So there's actually, this is a little trickier because there's more sort of, it's not just three things, right? So you want to sort of think about the various ways that this project is, the kinds of land use and environmental impacts it's going to have. Questions? All right, so let's break into your teams, and then I will come around and talk with each of you.